Well, we're getting close to 10 o'clock here. I think we'll go ahead and get started. Try to be respectful for everybody's time today. I don't think I see anybody else out in the parking lot coming in, maybe one additional person talking. You do have copies of today's presentations on your table. There are some drinks and snacks off to the side. We've got some cards and additional presentations if you get a copy off to the side too. If you need the restroom, it's just out the door to your left down the hallway. So first and foremost, thank you for coming today. My name is Courtney Yockey. I'm with the F&M Regional Growth Alliance, but here today representing the Business Navigator Alliance of Southcentral and Southeastern Illinois. We got an excellent presentation stored for you today. We got Brian Wacker from the Cook Group. Brian's going to talk about the Illinois Paid Leave for All Workers Act. Very much looking forward to hearing your presentation today. But maybe to get started here, before we dive into Brian, is who is the Business Navigator Alliance and why am I up here? So this is the Business Navigator Alliance hosts this monthly webinars, and this is kind of the best in both worlds in that this is a calls together event, in-person event that Angela Griffin has put on for you guys. And then we're also live streaming it, so that's why you see the cameras here today as well for our webinar. Obviously, I'm not Angela. Unfortunately, Angela wasn't able to attend today, but I'm obliged to come up and step into her shoes and try to do a good job in facilitating. So with that being said, if you do enjoy today's event, please direct all your comments to me. If you have complaints, please direct them to her. But we'll have a good time. So who is the Business Navigator Alliance of Southcentral and Southeastern Illinois? Well, we are a 6-county regional collaboration working through the Small Business Community Navigator Grant through the Department of Commerce and Economic Opportunity. For partners, it is Coals Together, Sullivan, Illinois Chamber and Economic Development, the F&M Regional Growth Alliance, the Crawford County Development Association, the Marshall Area Chamber of Commerce, and PEDCO, the Paris Economic Development Corp. Our mission is to ensure that small businesses in our region are competitive and applying for the necessary resources. We're charged with outreach and technical assistance for local, state, and federal programs. We host these webinars on the last Thursday of each month, typically. Please go to ilbusinessnavigators.com. That's navigators with an S. To learn more or to sign up for our newsletter so you can stay informed on various events or opportunities that come up that we try to do promotions on. We do offer outreach, additional outreach events. We offer virtual business office hours and a lot of technical assistance in that one-on-one setting. So do go to ilbusinessnavigators.com and check us out there. A recording from today's presentation will be on that website as well. A recording from our previous presentations on there's two. There'll be a copy of the presentation that you have here sent out to you. Everybody that is attending virtually today, a copy will be sent to you as well in a follow-up email, and a recording from today will be sent out as well. So to introduce Brian, Brian is a partner with the Cook Group, a regional law firm with offices in the Midwest and the East Coast. He has practiced law for nearly 15 years in Illinois, Missouri, with a heavy emphasis on representing employers, small business owners, and fiduciary in litigation and risk management. Brian has given a dozen presentations to Chamber of Commerce and trade groups, providing topical guidance on current legal trends and new legislation relating to the employer obligation, anti-harassment training, recreational cannabis, and drug and alcohol-free workplace policies. Brian lives and works in St. Louis, where he and his wife raised their 2 kids, 6-year-olds, and they are twins. So, be easy on them, especially during the summertime here. We were talking earlier with his kids getting ready to go back and go into school, and just the excitement there. So definitely a lot going on in his world, but we are very fortunate that he has come down here today to be able to present on this topic, a topic that impacts everybody, especially employers here in Southcentral and Southeastern Illinois. Brian.
All right. Thank you, Courtney. I will tell you that the excitement in my house for my kids to go back to school is definitely on my wife and I's side. I don't know how excited they are, but we are ready for them to be back. Yes, as Courtney said, my name's Brian Wacker. This is probably the first, I'd say I see some familiar faces here, but this first time I've probably presented in the area in a few years. Probably last time was probably in Charleston or Effingham, might have been before the pandemic and everything got sort of turned upside down. I probably had hair back then, and things were a little bit different in terms of what the employer obligations were in Illinois, and it seems like they keep sort of piling them on you guys as employers, especially small business owners in Illinois. And so what we're here to talk about today is what I think is the newest one and probably the one you want to be most aware of with respect to what's going to be going into place next year, and that is the Paid Leave Workers Act, or Paid Leave for All Workers Act. So before we get started, I guess I'd have a question for you, because as we go through, some of these things will apply to some of you folks and some will apply to others. Does anyone here already have a paid leave policy in place for their workers? Okay, so to the extent that you have a paid leave policy in place already for your employees, to the extent that it already provides them the minimum requirement under this act, which is the 40 hours or 5 days over the course of a year, you're really in pretty good shape. You're not going to have to be doing too much to your policies. There's some tweaks you'll probably have to make to the extent that they don't comply with some of the rules in the act, but you're probably in good shape. There's not much you're going to have to change. It's for the folks that don't have formalized paid leave policies in place, or if you just don't provide paid leave at all, that we're going to have to really take a look at what's going on and be ready for the new obligations that come out in beginning of January 2024. So let's get started, and I apologize for all the neck craning. This is the highest mounted TV I've probably ever seen in my life, but we'll work through it. We appreciate the fire code and having to have that right there. So all right, so let's talk about the act first. So this was an act that was enacted and signed into law in March. And basically the legislature, as they do with any sort of, in their infinite wisdom, of course, in Springfield, anytime they pass something, they tell you why they passed it. So the purpose of the legislature put out there is that this act is providing paid leave, which is crucial to the health, happiness, and family responsibilities for all employees. It addresses what is at least a perceived gap in paid leave that's available to certain workers in the state, but not others. It's intended to promote fairness, inclusivity, and a healthy work-life balance for employees. In theory, it would attract new employee talent to the state, knowing that folks, living along the border would say, hey, I could take a job across the border and get better benefits than you'd get in Missouri or Indiana or Iowa. And it's specifically not designed to discourage employers from adopting and having their own policies, right? This is sort of just the minimum requirement that's going to be out there, absent a policy that's already in place with an employer. Governor Pritzker, for his purpose, he said the purpose of the law is to alleviate working family burdens, to benefit employers with increased productivity, and to gain a greater passion for their job when they can manage the stresses they face outside of work. For their part, some of the industry folks, there's a lot of lobbying that went on to get this passed, and some of the industry folks are okay with this, right? So we have the Retail Merchants Association talking about the consistency and simplicity it provides for employers. It is a fairly straightforward act when you start comparing it to other burdens that are put on employers in Illinois. Folks talking about the Manufacturers Association talking about striking the right balance between burdens that are on employees and business flexibility and the giving time off to the employees that need it. And certainly labor groups like the CIO or AFL-CIO, healthcare unions, Poverty Law Center, all behind this legislation, because in fact what this legislation is Illinois is only the third state in America that has a minimum paid leave requirement now, or that will be in effect next year. I would open this up. Anybody want to guess what the other two states are?
Certainly not California.
It's not California, actually. One of them is Nevada, which is very, very heavily influenced by labor unions in Reno and Las Vegas, and the other one of all things is Maine, which Maine kind of just does their own thing. I guess they're the furthest right on the map, and they just kind of try to move everything across the map. I'm sorry?
Who was first, Nevada or Maine?
I actually don't know that. I can look that up, and we'll ask Google later and see. So, all right. But as you may imagine, not everyone loves this. Tony McCambie, the Illinois House Republican leader, says that these mandated benefits could have a detrimental effect specifically on small businesses in what is already an unfriendly business environment here in Illinois. And there is also the criticism that this really does try to impose a one-size-fits-all mandate on employers, which, kind of sends the message to maybe we can just start up our business across the border or somewhere else. So it has come with some mixed reactions, but as you guys all know, it passed, and it passed with pretty overwhelming support. So it's going into law, and subject to the regulations we're going to be hearing about from the Department of Labor, which have yet to come out, we're going to have to be ready for it. So, quick refresh. Illinois law with respect to paid leave off, mandates for paid leave off, statewide, there is no guaranteed right now paid leave off for taking sick leave, childcare, for mental health reasons, for medical appointments, vacations, or for any other reason. There are requirements, as you know, for providing unpaid time off for certain reasons, but none for paid time off at this point. So let's go over what are sort of the key provisions of what is going into effect, and then we're going to sort of kind of break down each of those and talk about each of them in more specificity. And again, as Courtney said, afterwards, if you have questions throughout this, I'm happy to take them. But afterwards, we will have a sort of a Q&A session to go over everything, and I will give you my, if I know the answer, I'll tell you, and if I'm waiting for Department of Labor guidance on that, I'll tell you that as well. So, all right, so first off is the amount of leave. So let's look at the actual legislative language. It says, and this applies to all employees in the state, an employee who works in Illinois is entitled to earn and use up to a minimum of 40 hours of paid leave during a 12-month period, or a pro rata number of hours of paid leave provided under the provisions of this subsection. The paid leave may be used by the employee, and this is very, very important provision that's going to be, I think, sort of tough to swallow or tough to get used to, but it will be the new normal, for any purpose, as long as it is taken in accordance with the provision of the Act. So paid leave can be taken, what is accrued and what is earned under the Act is going to be allowed to be taken for any reason. It can be because a family member is sick, it can be because they just don't want to come to work that morning, or 8-9 days out, whatever your policy will say. It could be because they want to go to Vegas and blow all their money. It can be for any reason. Employer responsibilities. So in addition to making sure you're in compliance with, that your policy is in compliance with providing the amount of paid leave that is required, it also is going to impose a burden on employers to provide and maintain records of each individual employee's earned pay leave and their usage and what they have left at any given point. We also have, does anybody have sort of Department of Labor or state or federal posters up at work advising everybody of we're just going to add another, you're going to need a little more space on your wall in the workroom to put up another poster, essentially providing notification to your employees of what they're entitled to under the Act. And as with anything that an employee has, any right or entitlement an employee has, you are going to need to avoid taking any adverse action or retaliating against that employee for exercising their rights under the Act. And finally, there are employee rights and protections. Again, this is the idea of non-retaliation. We're not going to be able to penalize or discriminate against employees who properly exercise their rights under the Act. And of course, as with anything, there are going to be potential remedies and litigation that will result out of this, providing some pretty harsh remedies against employers who are not in compliance. So, let's start sort of breaking all this down. First of all, let's talk about who here is covered. Before we get to the next slide, does anybody here have union workers? A couple few of you. Anybody have exclusively union workers? So, okay, so in large part, everybody has their own employees here. So who is covered under the Act is every single private employer in Illinois. So if you have 1 or 1 million employees, you are covered and all your employees are entitled to the minimum paid leave as required under the Act. There's not any exception based on size. There are certain federal laws you guys may be aware of where you don't have to comply if you don't have more than 10 or 15 or 50 employees in certain areas. That is not the case here. This is state law, and if you're in Illinois and you have an employee, even if that employee is yourself or your wife or your son, you are required to provide them that paid leave. Now, if you have a collective bargaining agreement in place, if you are working with unions, if that is in effect on January 1, 2024, if you've got a 5-year agreement that you guys negotiated this year, this is not going to affect the validity of the collective bargaining agreement, and it's not going to affect the paid leave requirements that you've negotiated. However, if you've entered into it after January 1st, 2024, the paid leave requirements have to be in there. The minimum requirements have to be part of that CBA and only can be waived if in the negotiations of your CBA, you come up with clear and unambiguous terms in the CBA saying that those provisions have been waived. So there are certain exceptions after talking about all the people covered, there are some certain exceptions here that are not covered. And I don't know if this really applies to anybody here, but we'll this is how sort of the lobbying groups kind of got together and started lobbying the folks in Springfield to kind of get these exceptions put in there. Is if you work for a school district, if the employees work for a school district, park districts, railroad employees who, I don't know if folks read the news, but the railroad employees have their own law on everything, and so they're kind of accepted out from this. A good one, I think, for folks is temporary college and university student employees, and I think that might be misconstrued, though. It's not, oh, I've got some college kids working for me for the summer, I don't have to give them paid leave. No, this is kids who are at school, they're at Eastern, and they're working at the cafeteria while they're there for the season or for the semester. They are not covered by this. And then certain construction workers and other workers in freight and delivery that are working under CBAs. So aside from that sort of finite list of folks who are accepted out of this, everybody else is going to be entitled to the paid leave as required by the new statute. Okay, so we're going to talk about accrual of paid leave, what's required under the statute, and duration of leave. And as we get through this, I want to sort of, the slides may not be as sort of, because the legislation is not particularly clear, but basically we're going to be talking about 2 options that you're going to have with respect to providing the paid leave to your employees. The first is sort of on this accrual basis, which might be how you guys provide paid leave at this point, where you sort of say, hey, if you work X amount of time, you earn 0.7 hours per pay period or whatever it is, and then that's how they accrue things. We can do an accrual basis that has to meet the minimum requirements of the Act, or we can do something that's called front loading, which we'll talk about the sort of the mechanics of that. I was actually surprised reading through the legislation that they use the term front loading, because front loading is what my wife calls when it's like a Sunday afternoon and she wants to have a few drinks, but she doesn't want to be hungover. So she says she front loads. She has like 2 or 3 drinks till about 4 or 5 o'clock, and then she turns it off. She calls that front loading. Maybe I just live in a different world than the legislators, but we'll talk about front loading as the other option too. All right, so let's talk about accrual first. So we obviously, everybody sort of has a basic understanding of the difference between non-exempt and exempt workers. With respect to non-exempt workers, these hourly workers that you've got, they are going to, at minimum, be required to accrue 1 hour of paid leave for every 40 hours worked. So if you have a full-time, 40-hour a week, 5-day a week, 8-hour shift worker, they get 1 hour of accrued paid leave each week, up to a minimum of what will be 40 hours for the year. For exempt workers, these are folks who either work 40 hours a week or just hit the exempt requirements. They accrue 40 hours a week in accordance with their regular work week. So sort of kind of breaking that down a bit, employees at minimum, as we're sort of going through this, employees have to be permitted to earn up to 40 hours during a 12-month period, right? During the 12-month period. Now, for all your current employees, this is going to be fairly straightforward because January 1, 2024 is going to start that 12-month period for them. Where it will become complicated and laborious and sort of tedious is when you hire someone on February 15th, right? You don't get to say, they don't get to tell you I get 12 or I get 40 hours from February 15th to December 31st, right? They get to say I get it from February 15th till February 14th the next year. So it is a 12-month consecutive period. And so the legislature kind of made this clear, saying that the 12-month period may be any consecutive period that the employee designates in writing or at the time of hire, and that changes to this period can only be made, and this was something you'd have to sort of provide notice to the employees for it, is if the employer gives the employee written notice prior to any changes, and if the change to the period does not reduce the eligible accrued rate and paid leave that's ultimately available to the employee. So you can't change the period in some sort of way to manipulate time frames to where they would not be otherwise entitled to earn up to the 40 hours of paid leave in the 12-month period. That being said, there are some sort of protections here to say, hey, 40 hours is sort of, if you don't have a policy that already provides more, you can put a cap on it, right? Employees cannot accrue more than 40 hours at any given time. And this is sort of employee friendly. If you're going with the accrual route, employees will be able to carry over unused accrued leave, right? So they get through their first 12-month period, they've accrued 40 hours of paid leave, they've only used 35. They can carry that 5 over to the next 12-month period, but they can still sort of, in terms of what is minimally required, you can still sort of cap them at that 40 going forward. So how much is paid during paid leave? This would be fairly straightforward, but perhaps it's not. If it's a non-tipped employee, exempt or otherwise, the employee is going to be paid at full regular wage while on leave. That includes benefits. The benefits, you can't reduce benefits. You can't change anything in terms of their what they're otherwise receiving during that time frame. If you have tipped employees, does anybody have tipped employees here? Okay. You have tipped employees, you are required to find out what the minimum wage is in your jurisdiction. And to the extent that they're not otherwise making that, you have to pay them at the minimum wage in that location for the time period of the leave that they've taken. So the Lauren Wacker special, my wife's special, the front loading is a little different. And I think front loading, especially with respect to folks that already have PTO policies in place, you may effectively already be front loading, or you may already have, my firm, for our staff, we have something called unlimited PTO. I don't know if anybody has dabbled in this yet. It actually is a great thing ultimately, because studies have shown time and time again that providing unlimited PTO to your employees reduces the amount of PTO they actually take, which is great. It's kind of a head game that goes on, but front loading is sort of a subset of that. Or if you guys have PTO policies in place where you just provide certain amounts of PTO per time period, it's kind of what front loading is. But let's talk about how the statute defines it. So we're going to look at the legislative language, and it says that an employee may make available the minimum number of hours of paid leave. So here we know that to be 40 hours, subject to pro rata requirements, to an employee on the first day of employment or the first day of the 12-month period. So in other words, on January 1st, 2024, if you put a front-loading policy in place, every employee already has 5 days of PTO that they can use, right? That is they've got that for the year. They've hit their cap. They're not going to earn anything more, and they can use it as they go forward for the year. It also says that employers that provide the minimum hours of paid leave to an employee on the first day of employment or the first day of that 12-month period are not required to carry over paid leave. So this is important, right? So on the accrual front, you are required to carry over. So if there's 10 hours that haven't been used, that carries over to the next year. In the front-loading policy, as statutory language says, you are not required to carry it over. And you may require employees to use all of it by the end, basically use it or lose it sort of policy, right? However, this is sort of the caveat to it. You can't use the front-loading policy to prevent or to give the employee anything less than that they would otherwise be entitled to, otherwise would have accrued over the year. So if you have an employee who's working full-time that was going to work enough to earn at 1 hour for every 40 hours worked, they're 40 hours for the year, you can't use the front-loading policy to say, no, you only get 35, right? If you have an employee that works 1,000 hours a year and that's going to earn them the 25, you can say, yeah, you're working 25 this year, or you're working 1,000 hours this year, you're going to get 25 hours of paid leave. But if they work more than that, you're going to have to provide them that additional, if over the course of the year, their hours go up, they work more, you have to provide them everything that they otherwise would have earned that year under the accrual system, up to the 40 hours. So again, I asked if anybody had PTO policies in place already. Does anybody use the sort of banking, the idea of like you bank your hours, you kind of have I've got 4.5 days banked and I'm going to use it for vacation or things like that. If you do have the bank sort of system in place, there is not a requirement in the legislature that you necessarily have to credit that employee's existing bank of PTO, sort of adding more to it. However, if you do, then if you have that banking system in place and you do credit the PTO bank, then all of a sudden the PTO that otherwise would not have been, as we'll talk about in a minute, recoverable if they're terminated or separated from employment, that actually becomes paid leave that is recoverable and is something you have to pay out after the employee is terminated or separated pursuant to the Wage Payment and Collection Act. So you can see that there is certainly interplay with respect to a lot of the, whether they wanted to or not, a lot of the current law already in place. So again, sort of stepping back to talk about, again, I inserted this slide last night, so I'm not sure if it's in your papers or not, but I kind of wanted to just sort of make it a little bit clear that, you know, when we're talking about how we're going to address, if you don't have a policy in place that already meets these requirements, how are we going to address it? You basically have two essential options. First is going through the accrual system, which is, you know, I've sort of put in the legislative citation to sort of what covers or what actually talks about this. You can go the accrual route where paid leave gradually builds up to a minimum of 40 hours over the course of the 12-month period, in which case if an employer opts for that, it has to allow employees to carry over all unused accrued paid leave from one period to the next. Again, we talked about this. If you get to December 31st and there's 10 hours left, you gotta let them carry that over. However, if you go with the front-loading system, employees are provided with 40 hours of paid leave on the first day of the 12-month period, and there's no requirement for the carryover to the next year. So again, you're going to have to kind of talk to your HR folks, talk to anybody who's making personnel decisions, talk to your attorney, and figure out, all right, which is best for us, which makes the most sense for our situation. I could certainly see if you have a larger number of employees, front loading may be what you're looking for, right? Saying, hey, you get this right away, you can use this at different points. We're going to put sort of policies in place on when you can use it. Notice you got to give us for it, which we're going to talk about in a minute. It may be better. Accrual may be better for your small businesses, for the folks with, smaller number of folks working there, knowing that, you don't want to, if you want to avoid, sort of an immediate run on taking these hours right at the beginning of the year. If you want to have people actually, quote unquote, earn the accrued hours over the year, accrual may be the better option. But again, they're both options on the table. They're both options that will meet your minimum requirements under the Act. But you're going to want to really kind of make the best decision, and you can certainly change it later on after, with enough notice to your employees, but I think it's going to be something you want to put a little thought into. So, all right, let's talk about some other rules, because what would legislation be without sort of a lot of rules? So we got 2 more slides of rules that we got to be thinking about. The first is employers are prevented and prohibited by the Act from interfering with, denying, or in changing an employee's work days or hours in order to provide them eligible paid leave time. So this is sort of the idea that, I've got an employee and she's working 1,200 hours this year, and that means she's going to earn 30 hours of paid leave. It says, well, I don't want to give them paid leave, right? I don't like her. I don't want her to, I think she's going to abuse the system. I don't want her to take it. I'm going to reduce her hours to 900 hours next year in order to prevent her from getting as much paid leave as you can. You can't do anything you can't make any sort of employment decision with respect to employees where their use or non-use or eligibility or non-eligibility to this paid leave and how much they're getting is a factor in your decision making. One question that I've been asked quite a few times is, can we just negotiate this away, right? Can we just say, look, I've told these guys know that they have the rights under the Act. They know that they're entitled to this, but I'd rather pay them $1,500 in additional salary in order to get them to show up for those 5 days that they're otherwise taking off. And they're making more in those 5 days than they're otherwise taking off. Can I just do that? And the legislature was crystal clear. The only non-run-on sentence in this entire piece of legislation is the provision that says agreements to waive rights under the Act are void as a matter of public policy. They cannot exist. Illinois has said our public policy is people get paid time off, and if the employee wants what they've earned, what's required under the Act, that's what they get. So you cannot negotiate it away. Another question I have is if you work for a larger company, if you got a corporation that has different divisions, different locations, within Illinois at least, a transfer to a new division or even to a new entity or location by the same employer, they're still being paid by and employed by essentially the same employer, that cannot affect the amount of paid leave the employee is entitled to. So for instance, you can't, halfway through a 12-month period, find an employee and say, hey, that employee's he's got his front-loaded 5 days that he still hasn't used. Let's go ahead and shift him over to, the other widget factory, and he will lose those and he'll have to start accruing them again, there, and it's going to effectively reduce or eliminate any of what he is entitled to. That you can't do that. So the courts, or the legislation has said pretty clearly that we're going to construe this legislation, is supposed to be construed very broadly to say that in any sort of circumstance where we're talking about whether an employee is entitled to paid leave or not, we're going to construe it towards the employee being entitled to it. And so in that sense, if we're talking about an employer, even if it's they were employed by Acme LLC and then you transferred them and now they're employed by Acme Inc. If they're related entities, if their divisions part of the same mothership, you're going to have to continue to pay them, and they're going to have to be able to carry their paid leave over to where they get moved to. So if it's the same employer, then the accrued PTO moves with the employee. That being said, unlike, and we talked about this a little bit earlier, unlike the Wage and Payment Act, where if you have earned PTO under a policy, that's something that has to be paid out upon termination or upon separation, in most circumstances at least. Here, there is no requirement that if you fire an employee on April 30th and they've accrued 2 days under this minimum requirement in the Act, there is no requirement that you have to compensate them for that unused time, right? So you do not have to give them 2 days of wages under termination or upon termination, separation, or retirement. Obviously, this is going to be subject to your own policies that you put in place. If you have policies that do permit that, which is something employees like, your policy is going to sort of overrun that. But as to the statute itself, if an employee comes to you and says, "You just fired me, I had 3 days banked, I had 3 days that had built up," you do not have to pay that out, at least at this point. The other question is though, we have a lot of folks that have seasonal hires. So you've got the landscaping company that hires the same guys who come cut grass every year, and they're on for 6 months, off for 6 months. If you rehire someone who's either laid off, separated, terminated, whatever, within the same 12-month period, you then have to go back to and we'll talk about the record-keeping requirements in a minute. You got to go back and say, all right, we're still in this 12-month period. How much did he have when he left? All right, if for the rest of the 12-month period, that's where he starts. That guy comes back, he had a day and a half of accrued PTO. He starts with a day and a half and he starts accruing more from there if it's within the same 12-month period that he was initially working under. More rules. So, employees are allowed, so again, this is, if there's other leave that exists, right? Other potential leave that an employee would be entitled to, whether it's medical leave, bereavement leave, unpaid leave, things that they're otherwise entitled to use, they can elect to use the paid leave that they are getting under this new law first before using any other leave that's required by law or that's otherwise required by other policies you guys have in place. So I think the big question that I've heard from, that I've read about, I've heard from some small business owners though, is look, I mean, I've got 15, 20 employees, like people just sort of willy-nilly taking time off at any given time it's a burden, right? I've got an essential employee. I've got 2 guys who can drive this truck and both of them want off this time. So there are rules in place that allow you to protect against that, at least to try to minimize the inconvenience and sort of annoyance that is going to come from this as employers. So one of those rules is that the employers can set, and again, this is legislative speak, it's called reasonable minimum increments, right? So it's got to be reasonable. What is reasonable? If you can tell me what reasonable is under the law, you guys are better attorneys than I am. But reasonable is always open to interpretation. But what is a reasonable minimum requirement for the use of paid leave? Well, they did give you sort of a baseline. They said, okay, you can require that no less than 2 hours be taken per day, right? That you can't have someone who said, you know what, I got my 40 hours for my front load. I'm just going to work 7 hours a day instead of 8 hours a day for the next 40 days. You can't do that. You can set at a minimum that you can require that no less than 2 hours per day be used. You can also set policies, and again, these are policies that you're going to want in place within your handbook, within your PTO policy. You can require that the employee wanting to take the leave provide you, when it's foreseeable, 7 days notice, right? So they make the request, you put in your policy, you say, look, you guys are getting this PTO, if you want to use it, you got to give us 7 days. So what is foreseeable? Foreseeable is the idea of, they're using it to go on vacation. They're using it to go to their daughter's wedding. They're using it to do something that is otherwise planned, that's otherwise on the books. You can say, hey, you got to give us 7 days notice before you make this request. If it's foreseeable, unfortunately, you have to allow them to ask you in writing or orally. It can be an oral request, right? So if you put in your policy, you've got to give us notice of foreseeable request for PTO. If you say, hey, it's got to be in writing, you got to send it to HR, you got to do it, you can say who it has to be sent to, but if you say it's in writing, the Act says no, it can actually just be orally too. I mean, it would be advisable for everyone, on everybody's side, to make sure it's in writing, but if leave is foreseeable and you've got some, my daughter's wedding, my son's got a baseball tournament in Dubuque, which is a thing. I'm just getting used to this child sports things that I just pray my kids aren't going to be athletes. But if it's something like that, they can ask you orally in writing, put a policy in place that says, yeah, make it in writing. If it's oral, we might have to have a little tiff over it, but really they can ask you orally. The key is you can't ask them why, right? You can't say, why are you taking that time off? Because the statute has said the purpose of the statute is to provide PTO so folks can use it for any reason or no reason, right? You cannot ask them why. This is for the foreseeable requests, but in your policy you got to say, hey, you got to do it, and you can't put anything in there like if you're saying in a written request that you've got to have, for what reason, or you can't do that. They wouldn't have to comply with that. They can take it for any reason. The converse of this is obviously, there are going to be unforeseeable events. We already know this. We know that there are times when employees just need to take off, kids sick, mom's sick, family emergency, car wreck, whatever it is. When it's unforeseeable and not requested in 7 days, you can put a formal notification policy in place. Meaning you can say, if you're asking for PTO on a Tuesday for the following Friday, 3 days away, you can say, hey, I need a formal notification. You're going to have to provide me a little more information as to why you're asking for this. And you can't ask why. And you can require it in writing, but it gets to that point where you're always asking for the doctor's note or the permission slip or whatever it is. You can ask them in writing, and you can try to do your best in the communications with your employees to figure out what it is they're asking for and why. You can't require documentation from them. So if it's hey, I got to visit my mom in the hospital, you can't say, show me the doctor's note. You can't say, show me the bills. You can't say, show me where you parked when you went to go see her or anything like that. And this is the tough part, especially for small business owners, you can't require that employee find a replacement or a substitute for the shift while they're on leave, right? So if it's a bona fide, legitimate, unforeseeable reason why they're taking the PTO, if it's a bona fide reason, that you can't say, okay, well, you can do that so long as you can get John to come in and cover your shift. Unfortunately, the statute just does not allow you to do that. So, when does it start? When does this all go into effect, right? So the statute or the legislation was enacted in March with an effective date of January 1st. That should say 2024 on there, I apologize. So when does it effectively start? It starts 90 days after January 1st, 2024. So the idea is, if you do the front loading, if you opt to do a front loading policy, it actually goes into effect on January 1st, right? Because you're providing them their eligible PTO right away that they can use for that first 12-month period. Because once eligible, employees must be permitted to determine when and how much they're going to use. And again, you can put those minimum increments on usage. But if you're doing the accrual system, right, and you're This is sort of the lag time that the legislature has put in. If you're doing the accrual system and employees start accruing it on January 1st, you're going to have to start letting them take it as of 90 days after, or March 31st, 2024. So in other words, we've got to be ready. If you're going with accrual, you've got to be ready to accommodate that leave on March 31st, 2024. So I asked earlier, who has existing policies in place? This is sort of the whatever dollar question it is what am I going to have to do now to really get ready for this? And the question is, all right, well, if you have a policy in place and that it already satisfies those requirements, in other words, you are giving up to 40 hours a week as a minimum, so 5 days of work, 40 hours a week, and this is PTO that doesn't require certain reasons, if it's just for any reason PTO, and your policy doesn't have sort of requirements of finding a substitute or formal notification requirements that aren't in compliance. If you have a policy in place that already meets those requirements, there's really not all that much you have to do. All you have to do is sort of, with your HR, with your labor and employment attorney, talk to someone, look over it and say, look, let's just make sure that the employee can do this for any reason, can do it with discretion. Let's make sure that the internal protocols we put in place for requesting leave and record keeping are compliant with what the statute requires, and you're in good shape. It's the folks who don't have policies in place, or more restrictive policies in place, or have certain workers that aren't eligible for earned PTO because they don't work enough or they haven't been there long enough. Those are the folks that are going to have to revisit those policies and really sort of craft something to at least meet the minimum requirements of what the Act has put on you guys. I want to take a minute to talk about, because at my heart, I am a litigator. I advise employees a lot, but I fight on behalf of employers a lot. And one thing that is, I think, really important is this anti-retaliation provision, right? So we have all manner of law that exists in Illinois, Missouri, federal law, every state, that protect employees from certain actions that employers take, right? You can't be discriminated against. You can't be harassed. You have certain rights under certain statutes, the Wage and Payment Collection Act, things like that, that employers have these rights and you can't get in the way of them. And in addition to not getting in the way of those rights, you can't retaliate against that employee for exercising their rights under those acts. You can't retaliate against them for instance, reporting that they've been harassed at work, things like that. Well, you see a lot of litigation that arises out of retaliation because employers, whether they know it or not, they're taking action sometimes that can be seen or at least inferred as retaliatory for just simply taking action that's protected by law. And these are very expensive. It's very expensive litigation. Whether you have it insured with your insurer or not, it's expensive, it's time consuming, it goes on forever, and the only people who really make any money out of it are the attorneys. So if you want to retaliate against everyone, my business card's over there. You can take that and just give me a call. But if you want to avoid all of that headache, it's important to pay attention to what the anti-retaliation provisions say. And essentially, it's a lot of the same language you see in these other acts, but it says that it's unlawful for an employer to use or consider the use, rather, of paid leave by an employee as a negative factor in any employment action you take with respect to evaluating, promoting, disciplining, or otherwise counting PTO against, or otherwise counting paid leave under a no-fault attendance policy. So essentially, you cannot use as a factor in any employment decision you make with respect to employees their use of PTO. If you're like, Jackie is just, she's totally abusing this. She only takes PTO at noon on Fridays because I know she wants to go out and she wants to get an early start on the weekend, and she's totally doing this. If she's doing what she's allowed to do under the law, you can't say, you know what, it really ticks me off that that's the reason she's doing it, where all these other employees they're taking it for legitimate reasons, to drive their kids to daycare or to go to doctor's appointments, things like that. You can't use that as a negative factor against Jackie when it comes to anything. And when I say adverse employment action is it's a legal term of art that's used a lot, but it can basically mean anything. It can mean I can't use that as a factor when I decide whether to promote her, demote her, evaluate her, change her position, her responsibilities, suspend her, terminate her, anything. You cannot use that as a factor, whether you are or not. You certainly can't put it down as a factor in writing on anything, but you cannot use it as a factor in making a decision with respect to an employee's job and their position within your company. So the idea is the Act has three sort of express prohibitions. Express prohibitions is like, it's legal, again, legal jargon for the three things you can't do, right? You can't retaliate against them for exercising their rights, which is taking the PTO that the law says they're entitled to. You can't retaliate against them for trying to oppose your practices, right? So if they say, look, I've read this law, I'm a armchair lawyer, I read this statute on Google, and it says that you need to be giving me this, and your policy doesn't do that, and they're a real pain in your, you know what, and you're going through all this, and whether they're right or not, you cannot use that as a retaliate against them for questioning that, or for coming at you and saying, hey, I want to talk about anything that has to do with their obligations and rights under the Act. You can't retaliate against them for taking any of that action. And you also can't retaliate against them for supporting others who are doing the same thing, right? So Jackie's being a real thorn in your side. You can't, her two cohorts who are, backing her up and saying, hey, you need to, listen to Jack, you can't retaliate against them either for supporting her. So this sounds like it's sort of, well, this wouldn't happen because we're going to have our policy in place and everything's going to go swimmingly. Well, as you guys all know, oftentimes with personnel decisions, things don't always go swimmingly with employees. And now that they're reading all these headlines and they're hearing things about what they're entitled to, you're going to have these conversations, whether you have the most pristine policy in place or the worst policy in place. You're going to get questions. You're going to get asked a lot about this. People who don't otherwise have PTO are going to be thinking that they have a lot more than they're otherwise entitled to. So you're going to have to be ready to not only be able to give them the proper notifications, the proper notice of everything, but also be ready to not use that against them when they become sort of that thorn in your side. Okay, so a couple of your sort of administrative requirements to walk through, then we'll talk about enforcement, and then I think we're at a good point to open up for the Q&A. So let's talk about the notice requirements. So we all know that certain statutes, certain protections out there require you to provide notice. These are all the posters you guys have up all over your break rooms. There is going to be an electronic notice that the Illinois Department of Labor puts out. As with everything with the Illinois Department of Labor, it's not ready yet, but it will be out and it will be ready for you to download and post prior to January 1st. There is an actual provision in the Act that will penalize you for not posting it, right? So if you have not put the notice up and someone reports you and there's an investigation, they find out that you haven't put the notice up, just not having the notice on the wall is a $500 fine, the first violation, and then each time afterwards, it's $1,000, right? And how is that interpreted? We don't know yet, but would it be crazy to assume that the statute or that the Department of Labor would say, well, on Monday you didn't have it up and that's $500. Then you put it up on Tuesday, but you took it down Wednesday, or someone took it down Wednesday, that's $1,000. Each instance or violation could potentially expose you to that. So, I don't know, laminate it, put it on put it in a frame, whatever it is, make sure it stays up. Because that's just it's an unavoidable, or that'd be an unforced error to be able to not have that up and be subject to a fine for it. The second sort of thing is record keeping requirements. Now this is important for two reasons. One is for enforcement reasons, which we'll talk about in a minute, but also it's basically for the benefit of the employer and the employee is, look, we've got this act, we've got all these new requirements. there's going to be tons of questions. Employees are going to come to you all the time. How much PTO do I have? How much can I take off next Thursday? Right? Do I have 4 hours? Do I have 6 hours? Or can I take the whole day off? So you have to, as you do with other employee records, personnel records, make and preserve records that document hours that folks worked, obviously, because that's going to be important to determine how much has been accrued, how much has been taken, and what remains in the balance for each employee, right? And you got to keep those contemporaneously with when work is happening. But in the same, for the same reason, you actually have to preserve these for 3 years going forward now. That's what the statute says. You got to keep it all for at least 3 years. Now, I know everything's electronic now, so it's probably not as onerous as otherwise having boxes and boxes of files for this. But you got to keep it for 3 years, because in the event that you're going to be a claim's going to be brought against you, you have to be able to. I mean, it would be good for your benefit, especially if you're following the law, to have these records to show that no, they got exactly what they were entitled to, and there is no claim. But you have to keep these in order for when the Department of Labor, if they look at a claim and say, hey, there's something here, they come knocking, they got to be able to come in, just like within a wage and hour audit or anything like that. They would have to be able to get access to your records. So we have enforcement, right? So enforcement is the Department of Labor, as with a lot of the other state employment statutes, is going to be who's in charge of enforcing it. Upon receipt of a complaint, they can conduct investigations. They can do it randomly as well, right? And so what this process does is it gives employees an avenue to file a complaint for non-compliance and really protect their rights in the event they're not getting what they're due. Investigations from the Department of Labor are, again, time-consuming. They're costly. Attorneys love them. But this is it's a state administrative action against you, where they can do anything from coming in and looking at your records, conduct interviews, take sworn testimony, issue you discovery, subpoena people. These are things that are really, I mean, they can if there's a real significant violation here, it could really cause some problems. And so employees, even if they got fired, they have a statute of limitations here, which is pretty significant for these type of claims, of 3 years, right? They can say, even if they're still an employee, 3 years from the time in which they said they didn't get their PTO, they can still file the claim. Like oftentimes you'll see with a harassment claim or something, it's 300 days or 180 days or things like this. This is 3 years. So that's why we're keeping our records for the 3 years. And if there is a violation, these remedies that they're entitled to are really, really tough, right? Small businesses, I mean, this could really be tough. And it's not just the violations, it's the idea that there's this equitable relief language in the statute that an employee could be entitled to. And that could include not just what they're owed in back payments, not just what they're owed in PTO that wasn't paid or interest or anything like that. That can include their attorney's fees. And that is a very strong disincentive for you to not keep the proper records and not give the folks their PTO, because that could be a very significant penalty. And this is for each violation. So if you have 100 employees and you kind of messed up on behalf of 100 employees, that can add up, because each person you didn't give PTO to or the proper PTO to, that's a separate violation all on its own. So that could be pretty significant. So enforcement, the last thing you want is the Department of Labor sending you something. So, all right. So what do we do now? This is kind of where the call to action, so to speak. We've got, today's July 28th, so we've got 5 months. So the idea is pretty simple. If you've got policies in place, you got to look at them, right? Or if you don't have policies in place, you need one. But if you have policies in place, you got to look at them and say, are we complying with what the statute says? And if you have an attorney who is seasoned at this and help you write those policies, get them on the phone, get her on the phone and say, hey, look, new act's coming through. I just saw this really handsome guy present on the Paid Leave Act, and I need to make sure that I'm up to speed. If you don't have one, you can always call me. But essentially, you need somebody who's got some significant experience, sort of understanding of the act, to make sure whatever policy you have in place as of January 1, whether it's the one you're keeping or the new one you're writing, is in place and is in compliance. And And then what I think is probably most important, just as important as the policies, is talking to and training your HR folks and your management and benefit managers on this, right? They have to know what the rules are, right? It's one thing to have a policy in place and say, hey, follow this. But really the idea is like, look, if there's going to be someone who every week is tracking hours, tracking PTO, figuring out who gets what, receiving requests for PTO, whether it's foreseeable or not, those sort of things need to be handled by someone who's trained and understands what the law requires. And then, of course, post and circulate that notice to all employees. What I would do is, in addition to sort of the initial posting it on a wall, anytime one of these new ones comes up, if you've got an email serve, if you've got message or mailboxes or whatever for your employees at work, print it off, put it in there. Make sure everybody gets a handheld copy of it at some point, or an electronic copy that you can say, hey, look, I gave it to you, and then put it up on the wall after that. And then with new hires, obviously, make that part of your new hire packet that you're giving them as well. So that being said, I think we're close to 11 o'clock, which is great. We're right on the dot, actually. So at this point, kind of open that up to Q&A, and happy to answer any questions, but I think Courtney maybe...
I'll help you a little bit with it. So first and foremost, thank you for educating this there. If we get a round of applause. Wonderful presentation. Very informative. Going to jump into a Q&A section. We have hit the hour. We'll continue on a little bit. We'll have a hard stop at 90 minutes if we do get into hour and a half. I know some people have noted earlier that they do have to leave, but hopefully you can stay with us. And if you're online, hopefully you can stay with us too. Just a quick reminder, a copy of the recording of this presentation will be sent out next week. And then, so if you do have to leave, you still can catch the Q&A. But we've had questions potentially coming in through the chat online, and we're going to just organically work through this process. And
if I've got the answer, I'll give it to you.
First and foremost, I'll get us started. And maybe if you could touch on it again. You did a good job talking about seasonal employees and noting the same 12-month period. And had covered a lot of different industries, but just recognizing that we're in Southcentral, Southeastern Illinois. What about the agricultural community and farmers as a whole, if you will, maybe to specifically narrow down, and that there are some different rules and regulations?
Sure, yeah. So within the Act itself, there are no carve-outs for agricultural. So you're going to be, if you've got a small farm or a big farm, you're going to be subjected to the same requirements as any other employee in the state. So if your growing season or the season you're getting folks out there is March to October, right? If their first day of that year is March 1st, that's going to start their 12-month period, right? And so March 1st is when they start to accrue, or you can front load them, however you're doing it. And then if they come back, so you've got them March to October, but then you bring them back in over December to, I don't know, cut Christmas trees or do whatever else you're doing, they're within that 12-month period. So if they had anything built up at the time they left in October, that actually goes back into what they're entitled to when they come back, because it's still within that 12-month period.
So keeping track of everything is very important.
Yes.
As you noted, and for 3 years too.
Yes.
So
yeah, the record keeping thing I think is important. I think most folks would initially see that as like, yeah, that's another burden, right? It's another spreadsheet I have to keep. It's another whatever I have to do. And I don't know if payroll companies are sort of preparing for this or not. If you're using Paychex or ADP or whoever it is, they may have something that they've already got in place in other states that they can use to help you track this. And that would be great, because one less thing to worry about. But it's important for you as the employer, right? Because if at any point you're going to have a problem employee or an employee with a concern, you want to be able to show them right away, like, this is what you have, you don't have this, and we know the law, we know the rules, and you don't, right? So it's better to have all that sort of tidied up on the front end, because the moment that somebody finds a thread or finds something that's not right, that's where the problems can get started. Yes.
And then maybe to continue on, just one more portion of that question. Independent contractors?
Yes. Okay. I'm sorry. Yes. So independent contractors are actually accepted out of this, right? And I think we had a slide on that may not have made it, or a line that got cut. So if you are using independent contractors are not required to be provided the PTO. But you always have to be careful on any of these fronts. Just because you call someone an independent contractor doesn't mean they're an independent contractor, right? There's always that test of whether someone's actually an employee of yours or not. So, yeah.
Any questions from the room or questions online? So, Blake, I see hand up first.
Two questions. First off, if you're on the accrual basis, you said it rolls over, does it ever expire? If someone just elects never to take it, does that just infinitely bill?
It doesn't
So
build.
repeat the question.
Okay, yeah. So the question I think is if you're doing accrual basis and someone hasn't taken it through the 12-month period and they've still got some that's rolled over, can it accrual and can they just make it, can it get up to 100 or 200?
Does it ever expire?
Right. Does it ever expire? The answer is no. Or yes, it does expire. So if you have a policy in place that allows them to accrue more than the 5, then it can roll over and it can be part of what is sort of, we talked about banking, it can be part of their sort of bank of PTO that they've built up over time. But if your policy says, no, we're doing accrual, but at the end of the period, it rolls over. It rolls over in the sense that for period number 2, they've already started at having, if they have 10 hours left for the second 12-month period, they've started with 10 hours of accrued PTO. They don't lose it, but you can set in place in your policy, and the Act permits this, it can only go up to 40, right? So they've got a 10-hour head start on the 40, but then when they hit it in September and instead of November hitting 40, they don't get to accrue anymore if under your policy you say that's what it caps at. Because that's all the statute requires.
So heavily dependent on your policy
Yes.
that you have current.
Yep.
And maybe to touch on the policy point, is it very common for businesses to have time off policies? I mean, I realize your larger employers, yes.
Yeah.
Thinking of mom and pop shops or, really the backbone to rural America for small businesses.
Yeah.
Is it a common thing to have these policies?
It's a common thing in my experience for folks to have unwritten policies, right? It's, I run my shop and I've got 12 employees, and if you need to take off to go take your daughter to school, or if you need a day off, absolutely, well,
Flexibility,
obviously, but to have in place written paid time off, not written time off, but written PTO policies. I don't see that a lot with employers that don't have, multiple locations or things like that. So
We won't go around the room and ask
I think
you
he had
raise your hands.
did you have a second question? Yeah.
It seems like this will be most burdensome for smaller companies that don't have, with variable hour employees, and you don't have a software system to do it for you. Have they come up with, like a better phrase, recommended or safe harbor examples to make, because part of this is also the communication of how to tell the employees what they have eligible and how to implement it. Is there any of that kind of guidance out there?
Not yet.
So repeat the question.
Yeah, okay, so you're talking about, in a lot of times when new legislation comes out, the Department of Labor will issue guidance, right? They'll say, this is a lot of gobbledygook, what does it actually mean? They will issue guidance with examples of, employee X has done this, why. As of last week when I checked, the guidance hasn't come out yet as well as the notice. You should get that though, because there is guidance on that. Do you guys all remember when the new sexual harassment training imposition came out? I might have trained some of you guys on this 4 or 5 years when that came out, but at that point, they delayed it and it didn't come out, but the Department of Labor did issue some guidance on that. What does it mean? What is it, what do I have to train on this? This should get the same thing, but we're at the whim of that at this point.
With that guidance, will there also be templates?
So templates, I wouldn't guess that there'd be a template policy, if for no other reason that the lawyers would say, hey, don't do that, you're taking our work away from us. But I think there will be additional guidance where you can say, all right, I'm looking at this statute, some of it doesn't make a bunch of sense to me, but I can take some of the language from the guidance and use that as sort of how I frame what I'm putting together. I think it probably will make more sense to the lay folk who don't, read through these things all the time.
You had a question, sir?
You review the payout when employment's over again.
So review the payout when employment's over.
Oh, sure. Yeah. So, all right. So if you are on a if you have someone who just, if it's the minimum PTO, the 5 hour or the 40 hours, 5 days worth, if you just have them on that, you do. If they separate, if they quit, you terminate them. You do not have to pay that out. However, if you have it as part of a scheme where you're providing more than the 5, and you've created that as part of their sort of banking system or whatever, the law has actually said that they're going to treat those 5 hours as actually being part of what they have to be paid out. So if you're not using that banking system and it's just, hey, I terminated you, or they quit and they had 3 days worth of PTO, you do not have to pay that out. Yeah. And that's pretty clear in the statute. There's not a lot of wiggle room on that.
Go ahead, sir.
Is there an age requirement to this? I mean, we're in the restaurant business, so I'm going to have to give 16-year-olds paid time off.
No.
Well, and so the question was, is there an age requirement for this? And then actually, I'll tag on to that one. Had a question, making notes. You had noted within the act, it specifically talks about college, university students, but what about high school students? And to your question, 16-year-olds working at his restaurant.
If they're an employee, they're an employee. And for as much as we'd like some common sense included into the definitions of these things, if they're an employee in Illinois and if you've got like 14-year-olds, you might have other problems, but if they're legally working for you, you got them on payroll, you're gonna have to give it to them the same as you do every. Now remember, if you've got a 16-year-old working 20 hours a week for you, that means over 2 weeks, they're earning 1 hour of PTO. Now, not to say that that's not significant when you add it up over the year with a lot of employees. But yeah, they are sort of entitled. My guess is you're going to give these guys, you're going to put that notice up on the wall in the back. Is it Jersey Mike's? You're going to put that notice up on the wall in the back of Jersey Mike's, and none of those 16-year-olds are going to read that, right? And you're going to give them the notification like you give everybody else when they get their packet, and they're going to look at it and they're going, I don't know what this means. I'm just going to make sandwiches, right? And then they're going to quit and go to school in September, or they're going to quit and get a different job, and they probably won't have availed themselves of what they're entitled to. And when they quit, you don't have to pay them off. You don't, like we just talked about, you don't have to pay them that off. So you got to give your employees notice of this. You got to post the notice. You got to put it in your policies and everything. But my experience with defending these claims and going through this a lot with employees over the years is that a lot of them really don't know what their full rights are. A lot of them, and you don't have to sit there, and again, I know this is being videotaped, so I'm not saying anything untoward, but you don't have to sit there and like beat on their door every month, be like, take your PTO, I want to pay you for not working. You got to give them, the notice that's required under the act, say, hey, this is what you're entitled to. If they take it, that's great. If not, it's not your job to make them take it before they quit, before you fire them, etc.
Well, begs the question, and then we'll jump into, what if you let somebody go and then they come back and work for you later that year?
Yeah, so that was part of one of the slides I was talking about. So the rehire sort of idea. If you're doing depending on when you hire, if you have them now.
Think of an industrial business manufacturer.
Sure, right.
And battle turnover. Every employer battles turnover, most certainly. But they leave you, they go make another widget for somebody else. They decide they don't like this, they want to come back to you.
Yep.
What happens?
If it's in the same 12-month period, right? So we're going to, except for the first year, I know this is kind of, we're just sort of abstractly talking. Except for the first year, when you're carrying over employees that already were employed with you on December 31st onto January 1st, those employees, their 12-month periods start in January 1st, right? Because that's when the act goes into effect. It starts then. But if you're a manufacturing company and the line's down until February, and then they start in February and they work till July, they leave and they come back. If they come back from between February and January 31st the next year, in that 12-month period, same employer, you gotta restore. You don't have to pay it. You gotta restore whatever they had left at the time they left to what they've got, right? So if they left with 10 hours built up, they're starting with, in your on accrual, they're starting with 10.
Good record keeping.
Yeah, good record.
For everything anyway.
Well, and that saves you half a day of trying to repiece it together because you open your spreadsheet. Yes, sir.
Are payroll programs such as QuickBooks and places like that going to be required or pick up on waste of report?
Yep, right. So you're right. So you're talking about our payroll, third-party vendors, things like that. Who are they required to put how much is in it, how much PTO a person has on every paycheck they get or pay stub?
Or even software, you had specifically noted QuickBooks, will they be able to
So
adhere to this?
There's nothing in the act itself that says that they have to, right? But I would say in terms of good record keeping and sort of covering all your bases, it wouldn't be a bad idea. I would imagine the payroll companies will say, look, I'm servicing 10,000 employers in Illinois. Maybe I should offer this as an
attribute,
an
yeah.
extra line item that I can put on to what we're providing them. The statute doesn't require them to do that. I think it would be a very good practice because it would ease the administrative burden on the employers in pulling this all together. I guess the counter to that is every employee is seeing at every given time like how much PTO. Maybe it's triggering something in their head to say, hey, I should take this PTO now, but they're going to know about it anyway. So no, there's nothing required, but I do think it's a good practice.
Excellent questions. Thank you. Can we take one online and then we'll come back? I see two over here.
So does this apply to county employees, state of Illinois employees, or not under a collective bargaining agreement?
So does this apply to county employees, state of Illinois employees that are not under a collective bargaining agreement?
Yes. So there are a couple exceptions in I think it's the city of Chicago and one other place where I don't particularly practice a lot. So maybe Cook County and city of Chicago that have their own PTO requirements that this by virtue of this doesn't supplant that. But with respect to employees, the definition of employer, the only exception, so employee is the meaning that is everybody basically that is an employee under the Wage and Collection Act is an employee under this act. The only additional carve out with respect to government employees in here is school districts and parks. So school districts organized under the school code and park districts organized under the park district code. Yes, sir.
Is the payout in hour increments? In other words, if you have somebody that has 70 hours of accrued time and they want to take whatever their accrued time off would be, they want to be paid, do they get 1 hour if they have 70, if they want to use it all, or is they just use it in 40-hour increments?
They can use it, so you can set like we. Oh, I'm sorry. You're talking about the increments of the payouts.
Right.
Sorry about that. Okay, so if they're taking it in the course of their, they have a pay period, right, and they've worked 35 hours instead of 40, and 5 of them they took off. You would just pay them 40 hours for that week, right? So you'd be paying them the 5 hours of PTO. You'd be paying them as if they were there, but they weren't. Is that?
Well, I thought you said you earned 1 hour of PTO for every 40 hours you work.
Yes.
So if you have less than a 40 or a number divisible by
Oh,
40, how do you draw it? They have 70 hours of banked accrual time, and they're leaving, but so they want to take their hour before they quit. Or
Right.
Are they entitled to 1 hour, or is it 1 hour and 45 minutes?
No. If they're quitting, you don't have to pay them out anything.
Well, they don't tell you they're quitting until after they draw the time.
Oh, I see. I'm sorry. I must not be.
I believe
This
that.
is real world. This is where
Yeah.
Yeah.
Jersey Mike's employees. What happens if they have less than 40 hours and they want to take a time off, but they don't have 40 hours?
Okay, so they can, whenever they have anything accrued, right? So there's two 40s in play in the equations, right? You work 40 hours, you earn 1 accrued hour, right? So you're talking about it's end of the year and
You don't have 40 hours. You only have 30 hours.
Right.
Have you earned anything?
There's no.
yes, you can use it.
Withdrawal?
You can, yeah,
Three-fourths of-
yeah. So once you start earning them, you can start using them after. If you front load, they can start using them right away. If you do accrual, they can start using them 90 days after the beginning of the 12-month period, which is going to be March 31st, 2024. And that's when they can start using them. So if they've built up 40 hours a week in 12 weeks, if they built up 12 hours in that first quarter, right, they would be able to, on April 1st, start using it if they want to. I don't know if I feel like I'm not answering your question, though. So
Let me get a stab at it. I might be able to get it for you.
Yeah.
At one point, can they use 1.5 hours
Yeah,
if they've only worked
so instead of.
You can
Okay.
make a policy that says that they can't take it in any less
Yes.
than 2 hours. Or
Yes.
company Policy is they can't take it in anything less than 4 hours. 4 hours or 8 hours, that's what you can do.
So you, the question and the discussion here is, and make sure that everybody can hear it, is, what if you have an employee that only worked another 20 hours versus 40? Are they entitled to that half
an hour, right.
versus a full hour?
No, because your policy is going to say a reasonable minimum increment, and the law has said that that has to be, you can do that to 2 hours. So up until 2 hours, if they only have an hour and a half, you can say, no, our policy says we have a reasonable minimum increment of 2 hours that it has to be taken at. And that's sort of to avoid, I think what you're talking, and I'm sorry for the confusion on that. And it's also to avoid sort of like, I'm just going to randomly take off an hour here, an hour there, and that's to avoid that.
So,
I mean, I guess you can accommodate that if you want to. You can say, hey, I'll let you take off at any given time within your policy, but the law doesn't require you to do anything more than 2 hours.
heavily negating
Less than 2 hours.
what's on your policy.
Yes,
And,
yes.
and what you provide
Yes.
that information to your employees, which also, if you don't have this in your policy, is somebody able to do a no call, no show and say, oh, well, I had an hour? I know if it's foreseeable, they're supposed to tell you.
If it's, yeah, I mean, that's a very specific question. If it's unforeseeable and it's, that they have the time for it and everything, you're going to have to kind of walk through your policy, see if it's something that applies or not. If it's really just, it's the morning of and it's a no call, no show, and afterwards they say, hey, I want to use that as my PTO, you don't have to, because that's not in accordance with the policy. The policy said, foreseeable or not, you got to give me notice, and you didn't give me notice. So that's just a day I'm not paying you, or that counts against you for no call, no show. I'm going to fire you for that. I mean, they can't just after the fact say, no, I had PTO built up, use that. No, it's got to be within. That's why the policy is so important.
And we'll get to you. You had a question back here. Go ahead.
Oh.
Oh, okay. So I'm not clear on the January start date versus employees we already have that have earned PTO. So like, for example, we just had an employee had an anniversary. So we've given him 5 more days. Let's say next month he uses all 5 of those. Come January 1st, you're saying he starts earning more, even though he really wouldn't have normally until his anniversary was back in July again, or?
So for this specific instance, what's happening before January 1st, none of that, I'm not trying to be glib, none of that matters to the law, right? So the law goes into effect on January 1st, forward looking. So you can't say, well, on January 1st going forward, you were going to earn your 40 hours that year, but you took extra last year, so I'm going to credit it against that. You can't do that. So the law is saying, as of January 1st going forward, that's when their entitlement to the PTO exists. They're not entitled to it now. So you may have just gratuitously given them extra time off, which just makes you a great employer, but it wouldn't affect what's going forward, what he's entitled to next year. But if you're talking about what does January 1st mean going forward, it means that is the moment when accrued or front-loaded, that's the moment when they have a right under the law to paid time off that they don't have a right to now, right? So if they are employees going, they make the hump into next year, if they're employees, their 12-month period under the law starts on January 1st, and during that 12 months, you have to afford them the opportunity for what they earn, for what they have to earn it at the rate that's required by the law.
On his anniversary date in July 2024, they'll earn that, right?
So no. So where the
Kind of
only
the difference between
Front-loaded on the higher date.
So the question here and the discussion that it's deriving to is anniversary dates, where that employee under current policy would gain another week, another 5 days off, as in your specific example, versus, all right, now January 1, does everything change? What about these? Yeah.
I'm sorry, I have another one that's going to get 15 days December 1st.
Right.
Is he gonna get 15 and then he's also
if he has, okay, if he has, under your current policy, minimum 5 days of PTO next year, then your policy is fine. That you don't have to give him 5 more on top of it. You've met the minimum requirements, what the act requires.
Hitting the 40 hours.
Yes, so,
But if he's used them,
So if he-
all in December, then I have to give
Yeah.
him more. I
If-
just don't understand how these things are merging together with people that already have PTO days.
so,
So if his anniversary date's on December 1st.
Right.
And he's entitled to 3 weeks of vacation, 15 days.
do you
And he
do you
uses-
front load that? Is it on that date he's entitled to 15, or does he earn it over the year?
Well, basically, it's like he earned it the year before.
Right.
So front loaded.
So,
Right. So, okay, so you're asking if he's savvy enough to, or if maybe he is going to, in that December 1st to December 31st timeframe, use all of his earned PTO, the 15 days. Does he then get the opportunity to earn the 5 more the next day before December 1st, 2024? Is that the question?
Come January 1st, does he get an
Yes,
additional?
if he's savvy enough to have done that, because his entitlement to the PTO begins on January 1st, 2024, and it has to be, the law is going to be forward-looking. It's not looking back at it. So that's a,
It could be a mess this first year.
So all our employees right now get 5 days on their anniversary. So any one of them, if they hit January 1st, say they haven't used any yet, so I still have 5, then we're good.
yes.
Yep.
But if they've used any so far, so say their anniversary was in April and they've used 3 so far, and then we hit January, they're getting a couple free days if I'm gonna front load January 1st.
Yes. Now, that's subject to the guidance that's going to come out. I mean, that question is probably a question that a lot of employers have, and there's Department of Labor is getting a bunch of those questions now to answer, so we'll have to see what the guidance says. But if I'm looking at the law or looking at it here, how it's written, yes. Because there's no retroactive application to this that talks about things earned prior to January 1st. It just says, as of January 1st going forward, employees have to be given the opportunity to earn at this rate, at a minimum. But just don't tell your employees. They won't take advantage of it then.
So right beside Teresa, she had her hand up first.
Yes.
So, this is for the employees that work 1,000 hours in that 12-month period.
Yes. So for employees that work 1,000 hours in the 12-month period, they'll earn 25 hours. They won't earn the 40 because they have to they earn 1 hour for every 40 hours worked over the year. So
Through the accrual.
through the accrual system, right. So you have to give them the opportunity, if they work enough at that 1 hour accrued every 40 hours worked. So if they work 1,600 hours, you have to let them earn up to 5 or 40 hours of accrued PTO. However, if they don't work that much, it doesn't have to be 40 hours. It has to be just what they accrued, right? So if they work 1,000 hours, that's going to be divided by 40. That's 25 hours they'll have accrued.
And that was your question too?
Yeah.
All right. Can we go online? I'll come back to you. Is there, okay, go ahead.
I have 2 questions. We have a 60-day probation period, and typically, somebody's first year, they're not going to have vacation, so we will probably write it into our policy and front load. Does it have to be, if you front load, does it have to be available to them the 90 days, or when they start?
So the current policies, you have a 60-day probation period.
Which is when they become full-time, so they
It's-
still get temporary until then, and then your benefits kick in at 60.
So the law, so you're asking, is there a distinction to be made based on probation period and temporary versus full-time or permanent employee? The statute as written doesn't make that distinction. So if you decide to front load, it will be the first day of employment, whether temporary or probationary or permanent.
But
where you're allowed that 90-day period?
With front loading, with front loading, they're allowed to start availing themselves of it right away. Yeah, so that's the difference.
So if you front load, they're eligible to take it ASAP.
Yes, if that's what you decide to do. Yes, yes. Accrual is, for the first year, it's that 90-day, you wait until March 31st, 2024. And that's how it's written.
So would
Wow.
you be able to front load it on their full-time date?
Would you be able to front load it?
So will we be able to front load it on that 60th day?
No, you would have to, they're entitled to it the first day they're employed. There's no distinction in the law as to between permanent, temporary, probationary, otherwise.
Front load current year employees and accrue, like our temporary employees, could we accrue for them?
There's nothing in the law that I've seen that prohibits you from treating certain employees one way and saying you're going to get accrual, if you're this type of employee, and that you could do front loading later. There's nothing in here that says you can't.
So our probation period people we could be accruing and then on their full-time day, front load.
So
So actually, here's my question. Here's my answer to that. In reading this thing 7 different times and going through everything I've read about it, I don't see anything that prohibits that, but I don't know if it permits that either. So you would have to. That's probably something we want to look to the guidance from the Department of Labor from, or I just don't want to give you a definitive answer on that because.
So it's still guidance, and just to make sure everybody heard the discussion, the question is, can you accrue during a probational period, and then once that person becomes a full-time employee, then front load, and just the distinction between that
Yes.
and how having probational periods coincide with what the act is, or at least how you can comply to it.
I think that's a very clever solution to it, and there's nothing in here that I've seen that says you can't. Or can or can't, but I think that's something you would want to dig a little deeper into before you start treating some employees one way and some employees the other way. But it's not dissimilar from if you have full-time employees that have if certain rights that temporary ones don't. You can certainly do that. So you don't always have to provide the same benefits to all employees.
Our vacation policy, you actually start accruing your vacation.
Yeah.
For your full-time hire date.
Yep. So long as the effectiveness of your policy, when you look at all of it together, is you're not depriving them of getting what they would be entitled to over that 12-month period, then you're going to be fine. I mean, because that's kind of clear in the language. It's like the purpose of this is to make sure every employee has the opportunity to earn up to the 40 hours a year, whether accrued or by front loading. So that is a good question. I would take my card and email me, and I'll try and get you an answer, a more definitive answer on that.
And then my other question on the 2-hour increments.
Mhm.
So I read it as you can't do anything less than to require 2-hour increments, but your slide kind of made me think 2-hour minimum for the day.
So for
So can they do 3 or 4, or can you say 2-hour increments?
You can provide a minimum increment, but that minimum increment that you're requiring is 2 hours. Like that's what the act says.
So we can say it has to be, so it either has to be 2, 4, 6.
Yes,
Okay.
2 or more. Right.
Hey, we've hit the 90 minutes. We can't catch.
Those are great
one
questions.
more question. Yeah, this is wonderful.
I love that.
discussion. Thank you for contributing. Last question here.
Simple question. Employer has several employees, some of them get 1 week paid vacation as part of their probation. Some get 2 weeks. Do they now have to give an additional on top of that? Or do they just change it from paid vacation to this?
So the question, different employees have earned different amount of time off, and how does that change to here now, starting January 1st? Is they have to give more, or does it fold into it?
Yeah, so with what you described, no one would have to get more, right? Because it sounds like everybody under that policy is getting the minimum required by the act, right? So if every employee is given the opportunity to earn those 40, everything you've described is already exceeding what they would minimally be required to be given that opportunity on the Act. So subject to changing some of the other rules that we talked about, I don't think you'd have to change anything on terms of what they're entitled to.
Last question, do they have to account separately for this versus the remainder if they get 3 weeks?
No, because what you can effectively think of is if they're already getting 3 weeks of paid time off, not sick leave but paid time off, it's subsumed by what's required. This is not an additional requirement on top of what they're already getting. This is a minimum requirement for all employees. So if what they're getting already exceeds that minimum, nothing to do, they don't get anything more, they've already hit the requirement.
You said this can't be called sick leave or personal leave, it has to be this.
If it's paid time off, it can be for any reason or no reason, right? So when I was talking about how sick leave is, now at least where it's unpaid, right? You're going to treat that separately, right? So they get their PTO, but if it's just if you're just talking about what they're already getting in PTO, paid time off, if that's already above that minimum, you're in good shape.
As long as it's paid, doesn't matter what.
Yes, sir. Yes, sir.
Excellent. Wonderful questions. Thank
I
you
hope
for
I didn't
digging
confuse
into
anybody
it.
anymore, but no.
A wealth of information. Can we give another round of applause? Most certainly, a heartfelt thank you for coming down and educating us today. We hope you found the presentation link to this recording. So I seen everybody taking a lot of notes. I've got a lot of chicken scratches myself. Definitely will be going back and reviewing it and making sense of it.
And on the PowerPoints, my contact information's on there. If you have any follow-up questions, just call me, email me. Happy to talk to you. Not charging you money or anything. Just I think it's good. It's helpful for us to all kind of learn as this is going to implementations or legislation's one thing, implementation's another. So it's a work in progress.
But again, thank you for coming today, and hopefully I did you justice in stepping into Angela's shoes. So I'm very thankful for being able to work with her and having a relationship with her and working on regional aspects. So thank you for obliging me to come here and do this for you today. We hope that you do join us for additional webinars. We do them the last Thursday of each month. Next month will be August 31st. And right now we're starting to put a webinar together towards housing and what they're doing down in Crawford County. But the state does have a few programs that they've recently rolled out, and we might dive into those as well. So hopefully you can catch us on the 31st as well. Thank you for coming.